Hello, everybody, and welcome back to our VWV Workplace Compass podcast. My name's Jess. I'm a legal director and knowledge lawyer in the employment team here at VWV. And today I'm joined again by two of our employment partners and my colleagues, Kiki Dawes and Naseem Nabi. Thanks to you both for joining me again for this second episode of our series on the Fair Work Agency. In this episode, we're going to be talking about national minimum wage enforcement, which we know is going to be one of the Fair Work Agency's key areas of focus. Before we get going, please do like and subscribe to our podcast so that you don't miss any future episodes on key changes under the Employment Rights Act 2025, which will be taking you through some of the practical changes ahead and what you can be doing to prepare for those. Right, so let's start with why national minimum wage enforcement is such a priority area for the Fair Work Agency. Naseem, do you want to kick us off by explaining the background?
Yeah, of course. Thanks, Jess. So employers will be well aware of the importance of compliance with national minimum wage. It's not a new area of enforcement, and for many years, HMRC has been responsible for enforcing the legislation on behalf of the government. It has powers to investigate breaches, make employers pay arrears and fines, bring criminal prosecutions, and publicly name employers who fail to comply. So the Fair Work Agency has now taken over these enforcement functions, albeit under a contracting out arrangement for the first year.
Okay, so if employers are used to HMRC national minimum wage enforcement, why are we talking about it today?
Well, although paying the national minimum wage is a pretty straightforward concept, the reality of getting it right all the time can be really difficult. We've taken a look at the last HMRC list of non-compliant employers. There are 389 employers named, being told to repay over £7 million in unpaid wages between them, and with over a further £12 million having been imposed in penalties. So this is clearly an area where employers aren't getting it right all the time.
Okay, so how then is the Fair Work Agency likely to approach national minimum wage enforcement in practice?
Well, the enforcement statement makes it clear that not every breach will be treated in the same way. The Fair Work Agency says it will look at factors such as how serious the breach is, how many workers have been affected, whether the employer has a history of non-compliance, whether the breach was deliberate or whether it's been repeated, and what steps have been taken to put things right. And those factors will influence whether the response will be an educational one, whether it will be a civil one, or in the most serious cases, a criminal one.
It's also worth emphasising that self-correction plays a big part. The enforcement statement makes clear that if an employer has correctly repaid all arrears before an investigation begins, a notice of underpayment should ordinarily not be issued. And if no notice of underpayment is issued, the employer won't be referred to the naming scheme either. So there's a meaningful incentive to act quickly if you discover a problem. But that only works if the employer has genuinely put things right before the Fair Work Agency comes knocking. Once an investigation has begun, it's too late to avoid enforcement action by paying up.
That's a really good point. Thanks, Naseem. And it might be worth then talking about some of the common misunderstandings that can catch employers out on national minimum wage. And back to you, Kiki. Are you able to take us through some of the mistakes that you tend to see crop up?
Yes, sure. So one of the most common that we see is the assumption that salaried workers are automatically compliant. An employer looks at a worker's annual salary, divides it by 52, and thinks that's that. But what matters actually is the effective hourly rate for each pay reference period, which is usually a month. So if a worker is doing significant overtime or if their working hours fluctuate, that effective hourly rate can drop below the minimum wage, even though the headline salary looks absolutely fine.
And that's a really important point, and the data backs this up. So around 500,000 salaried jobs in the UK are paid at levels where the minimum wage is relevant. When the Low Pay Commission looked at those jobs, they found that 44% of them showed underpayment, meaning that when you calculate the effective hourly rate based on actual hours worked, it came out below the minimum wage. So these aren't necessarily exploitative employers. Often they're businesses that genuinely thought they were compliant because the annual salary was above the threshold. The problem is that if actual hours aren't being tracked, you simply can't know whether you're compliant.
Mm, yeah, I agree with that. And I think we'll come on to talk about the importance of keeping accurate records in a while. And the other point that's occurred to me in preparing for this podcast is about younger workers and the fact that the age band rules can trip employers up fairly regularly.
Yes, there are definitely a few issues here as well. So the first is simply forgetting to increase a worker's pay when they move into a new age band. A worker turns 18 or 21 and their minimum wage entitlement changes, but the payroll doesn't get updated. And there are cases where employers have been named publicly for underpayment that happened simply because they hadn't updated their systems when a worker's birthday passed.
Yeah. And it's worth flagging that this is going to become more complicated before it becomes easier. The government has committed to removing the adult age bands entirely by extending the national living wage to workers aged 18 and over. The Low Pay Commission's current proposal is to move 20-year-olds onto the national living wage in 2027 and then 18 and 19-year-olds by 2028 and 2029. So, employers who rely heavily on younger workers should expect proportionately larger increases for those age groups over the next few years as the gap is gradually closed.
Okay, thanks, Nassim. And what about deductions? Because I think that's probably another area where employers can sometimes get caught out.
Yes, definitely. Deductions are a real minefield. The basic principle is that any deduction which is for something connected with the employment or for the employer's own use or benefit will reduce pay for national minimum wage purposes. So if you're making workers pay for uniforms or for required equipment or for DBS checks, for example, those deductions can push pay below the minimum wage, even if the gross pay looks compliant.
There's one partial exception worth knowing about. The Secretary of State has issued a direction that says employers won't face a financial penalty if the only reason for the underpayment was a salary sacrifice scheme or a savings deduction made with the worker's consent, where the worker received the intended benefit. But that doesn't apply to deductions for things connected with employment, like uniforms, for example. And it doesn't apply if the employer has had previous minimum wage breaches in the last 6 years.
Okay, so we've talked about why minimum wage compliance is maybe a bit more complicated than it might first appear. Let's just dig a little bit deeper into record keeping then, shall we? Because I think clearly it's really fundamental to being able to demonstrate compliance if questions are asked.
Yeah, record keeping is absolutely critical, and it's often where the challenges lie. So, employers are required to keep records sufficient to establish that they're paying the minimum wage. If you can't demonstrate compliance, you're in a very difficult position if there's an investigation. And the Fair Work Agency has got wide powers to require information and documents to be produced.
Yeah. The challenge is that for many roles, hours aren't neatly recorded. We see this particularly with salaried workers, with managers who work beyond their contracted hours, with flexible workers whose hours vary week to week. If you don't have accurate records of actual hours worked, you cannot calculate the effective hourly rate and you can't show you're compliant.
So, what should employers be doing then to protect themselves, do you think?
Well, there are some practical steps they can take. Firstly, audit your current arrangements. Start with the workers who are on salaries close to the minimum wage threshold and check what their actual hours are. Look at your deduction policies. Check whether there are any groups like younger workers moving into new age bands who might have been missed. And think about whether things like training time, travel time, overtime, is there anything that isn't being properly captured?
I think it's also worth remembering that if you do find a problem, Acting quickly really does matter. Self-correcting before an investigation starts puts you in a far better position than waiting until an agency identifies the issues. There's also a significant financial incentive to act promptly. If a notice of underpayment is issued, the penalty is reduced by 50% if all unpaid wages and half the penalty are paid within 14 days.
Brill, thanks very much to you both for your comments. And that brings us to the end of today's episode. So we've covered why minimum wage enforcement is such a priority area for the Fair Work Agency, some of the most common compliance pitfalls, and practical steps that employers can take to reduce the risk.
Yes, thank you all for listening. In our final episode, we'll be looking at holiday pay enforcement, which is a new area for the Fair Work Agency, and thinking about where enforcement priorities might head in the future.
And if you would like any more insights like this, please do explore our full Workplace Compass playlist or head to our Employment Rights Act hub for articles, resources, and all the latest updates. Everything is available on our website. Thanks again for joining us. We'll be back soon with our next episode.
Bye.
Bye.
Bye-bye.